So you all watched the process. The defense attorney has already asked for several continuances of the detention hearing. The final date's supposed to be today, and they did have the detention hearing, but he made the interesting argument that while not having ample time to go through the discovery, he seemed to make a point-by-point challenge of the discovery, which indicates that at least he or somebody in his office actually went through it. Look, the defense is entitled to make their arguments. That's what we have a court system for. And this defense counsel is entitled to make all of the arguments they think benefit their client. And I'm sure that they have a theory that says, for some reason, delaying this benefits it. I personally don't know what it is. I can't imagine what it is. And so that part will play out. But the judge made a ruling. The detention hearing was had. He's being held by the Middlesex County Jail. And there'll be another hearing in the future which will just concern the preliminaries of trial work. You're going to court, you prepare, you have your notes, you read from your notes, you want to make sure you cover everything. But the point I was making, that while he took very great pains to say that, and he kept using the phrase 6,000 pages of discovery, 6,000 pages of discovery, his vacation schedule, so on and so forth, that he did not have an opportunity to look at it. But in challenging the detention hearing, he went in a point-by-point critique of part of the discovery. And even the judge noted that for somebody who hasn't had a chance to review the discovery, he seemed to be remarkably well prepared. I didn't know that the gun was found in a fanny pack. I'm not sure that was necessary earlier in but the prosecutor went through some very detailed explanation about what the evidence was. And that was, the defense has the ability to rebut the presumption of incarceration. And so he made his shot at that. And of course the prosecution has the ability to come back, and she went through, Amber Gibbs went through in great detail all of the material they have that really substantiates incarceration. I think, again, the prosecutor's office was laying out a complete foundation as to the rationale for incarceration. But the state has to make that, as part of the adversarial process in criminal law, the state has to make that case. They did. And what Amber Gibbs and her associate were doing in that is just reiterating for the court all of the facts that go into justifying incarceration, that he had a prior gun charge, that he had domestic violence charges, that the gun was found in his possession in a fanny pack, that there was all of this evidence. I think it was easy pass transponders and telephone pings. So she was rebutting what the defense attorney was trying to establish, that he was trying to make the case that it was all circumstantial, which was clearly it's not. So one of the things that was discussed in court today, and one of the things that was discussed when the prosecutor announced the arrest, that as part of her mission as a pastor in this religious organization, they asked her to essentially supervise and provide guidance to this individual as part of her religious mission. And that's what I understand that relationship was. They identified, my understanding is that they identified this individual, somebody in their parish, in their congregation, that needed spiritual or social or moral guidance. And I believe that was the nature of the relationship.
Has her family ever said that she'd had problems with him in the past while he was living?
No, it's my understanding that the family is unaware of him, the relationship, who he was. Eunice was 30 years old, right? And, all of us who have 30-year-old daughters will not be surprised to know that there are things that, things they have going on in their lives that mom and dad don't always know about.